But now it's time to learn, folks.
Yes.
It's time to learn about history.
Book club.
Book club.
This week it was about workers'
rights. We are reading Supreme Inequality by Adam Cohen.
Yes.
The 50-year battle to make a more unjust America. I think that's the subtitle.
Yeah.
But we are talking about workers' rights.
Mm-hmm.
And we are going to start off in 2006 with Lily Ledbetter.
Mm-hmm.
We talked about her a little bit in the prologue of the book. On the first episode, we covered this book. But now let's get into the nitty-gritty. So Justice Alito just comes to the court, replacing O'Connor in 2006. O'Connor was the steady moderate.
Yeah.
She was the swing vote. She decided if the decision was going to go to the liberal or conservative side. Alito comes in, throws that spectrum, takes the balance that they had, throws it off a cliff. Mm-hmm. Alito is now probably the furthest right judge you got.
Yeah.
Maybe you can argue Clarence Thomas, but I'll die on the hill that it's Alito.
Okay.
Ledbetter was a very poor woman. She grew up in a small town in Alabama, and she picked cotton before entering first grade.
Just classic.
Classic.
Yeah.
I mean, and I think I think her story is so great. You know, she wasn't able to attend college, but she was convinced and had the conviction that she was going to get her kids to college and be able to save for retirement. She was going to have a better life. So she started working at Goodyear, where there were ads that women were going to start be adding to their management team. And she faced a lot of discrimination. At one point, she had to start bringing a gun to work because she was scared for her life.
Yeah.
Between the sexual harassment and everything. And while she was nearing her retirement, she found out that she was getting paid less than her male counterparts.
Yeah. There was a letter left for her, I think an anonymous letter, that listed her salary next to all of her male coworkers who were also managers at the same level as her and who had been hired around the same time as her.
Mm-hmm.
And it said something like she was making about $3,700 a month.
Mm-hmm.
And the men were making between $4,200 and $5,500 or something like that.
Yeah.
So just a blatant discrimination.
People with the same experience, the same job description, and they're making that much more than her.
Yeah.
Blatant discrimination. And so she files a complaint with the Equal Employment Opportunity Commission, and is saying that Goodyear violated the Title VII clause of the Civil Rights Act of 1964.
Mm-hmm.
The act says that the victim has to file a complaint within 180 days of an unlawful employment practice, and she showed that her case, that this was the case for her complaint, which will be important to remember. So after she gets that letter, she makes this complaint to the EEOC, and that all takes place within 180 days. A jury awarded her $3.5 million for the discrimination she faced. But then it goes to the Supreme Court. How does that go?
Unsurprisingly. They rule 5-4 against Lily Ledbetter, and the decision is written by Sam Alito, and he says that because she didn't file the complaint within 180 days of the first paycheck that initiated the pay discrepancy, that she didn't deserve the payout from the court.
I don't understand why it has to be the first paycheck. It makes no sense to me.
No, it made absolutely no sense. And I mean, that's what the book said. And this is where, I mean, we've talked about this many times. I'll mention it again. This book has a clear liberal lean.
Yeah.
We look out for the bias here. So I feel like I've been extremely alert in trying to think like, okay, is there information they might be omitting here?
Mm-hmm.
To me, it's blatantly obvious that if she filed the complaint within 180 days of any paycheck where this discrepancy existed, she should be awarded the damages.
Totally.
But Alito just decided, and I think one of the liberals in dissent specifically said, like, this is a classic, it might have been RBG.
It was.
Like, this is a classic case of judicial lawmaking, of us completely stepping out of bounds. And I agree with that. And that's why the Lily Ledbetter Act, Fair Pay Act, was the first law that Obama signed when he got into office in 2008.
Yep. Ginsburg says, fix this legislatively. Obama comes in and he does it. It's the first law he signs. So that was really cool to see. But now we're going to go back in time and talk about how it wasn't always this bad.
True.
and see some of the good things that came out of the 60s under the Warren Court.
Yes.
Okay. So the strength of the Title VII was unknown after 1964. And because it had some kind of vague language, and the vague language was kind of on purpose because it wanted to be almost as powerful as possible. Like in a lot of ways, you want it to be fairly vague so that administrators can take it upon themselves to enforce the intent and the passion behind the words as much as the words themselves.
But now what we're seeing, and I know you're going to make a point, but
Yeah.
what we're seeing is how dangerous it actually is to be vague because of the amount of power it leaves to what is clearly a partisan court.
Yeah. No, and I agree with that. I think during my time in Brookline politics, we were trying to pass a bill that had some fairly vague language, and the pushback was that it needed to be more narrower in scope and more defined. And my push was I wanted it to be more vague so that the administration and the department had more leeway to take action on things that have similar scopes, but things I didn't think about at the time.
Yeah.
But there is faults in that when you have a rogue court.
It feels like it's a really weird tension for liberals particularly who want to give the government more leeway to have more power.
Yeah.
And you do that by writing more vague laws. But if you also have to worry in the back of your head about a conservative court who's just looking to manipulate your language into something that you totally didn't mean, you kind of get stuck.
I mean, it makes it hard because it doesn't, like if you were to take just what the people who wrote the legislation meant, it would be easy. But that's not what's happening.
No.
They're not taking what the people who wrote the legislation meant, right? So
yeah, well, because I think there's no consensus on whether to make decisions by letter of the law or by spirit of the law.
Right.
Right. And it seems like you should always be trying to discern what the spirit of the law is and make the decision based on that.
Yeah. Yeah. And so we have more civil rights cases coming in through the 1960s. And the first one we're going to talk about is Duke Power in North Carolina. Duke Power in North Carolina favored whites when hiring for employing a test that whites were more likely to pass. So this case was between Duke and the NAACP Legal Defense Fund, and it came to the conservative court in the 1970s. Again, this is coming to the conservative court in the 1970s.
Yeah,
so
after Warren had retired.
Post-Warren, now we're in the Burger Court with the Nixon court. Lawyers argued that even if an employer did not directly discriminate, if it adopted selection criteria that disadvantaged a protected group and the criteria was unrelated to the job, then it should count as discrimination.
As a violation of the Title VII clause or whatever in the Civil Rights Act.
Yes. So the court ruled in favor of Griggs unanimously.
On the conservative court.
Unanimously on the conservative court. The Nixon-appointed conservative court was in favor of this unanimously.
Yeah.
And declared that Title VII barred not only overt discrimination, but also practices that are fair in form but discriminatory in practices that are fair in form but discriminatory in operation.
Yes.
The language discriminatory in operation, I think, that has so much power behind it.
Yeah.
Right? If you think about things that are discriminatory in operation, that's school funding, right? That's discriminatory in operation. The way the police departments are deployed, that's discriminatory in operation. And that admittance from a conservative court and that level of understanding of racial issues from a conservative court in the 1970s was really shocking for me to read.
Yeah, it was huge. And at this point, what was big is it set a precedent in future cases that defendants, companies, would have to prove that any job requirements they had were not, did not discriminate by the status of any protected group, and they were necessarily relevant to the job.
Them having to prove business necessity is vital here because it puts the burden on the business to now be more careful about it.
Yeah.
Because if it goes to court, it's on them. And that's what makes this really impactful. The New York Times at the time called this case a powerful engine of demographic change in the workplace.
It led to something, they called it a Griggs revolution because all across workplaces, companies didn't want to get taken to court. They saw that they were going to have to pay dues. And so they proactively started checking what their hiring practices look like, making sure they removed anything that wasn't directly relevant to the job, removed anything that discriminated. That was immensely powerful. And it just goes, again, to show the power of the court.
Right.
To see how these laws are actually going to be enforced.
Right. And this is a good example of like Title VII, the vagueness of Title VII actually being used for the purpose of the spirit of the law.
Yes.
Right? Because when it says demographic by or what does it say? Discriminatory in operation, that's not discriminatory in language. That's the opposite of letter of the law.
Yeah.
Right? It's the opposite of letter of policy.
Yes.
It's the implementation of the policy and the effects of it.
Totally.
So now we have another case. In the final months of the Berger era, 1986, we have Meritor Savings Bank versus Vincent. This was a young black employee said that she had been coerced by her supervisor into having sex repeatedly over several years with the fear of losing her job. Believe it or not, I guess that was not technically legal before the Civil Rights Act, which is insane.
That is insane.
So she rules for Title VII that this is a break in that, and the court ruled that sexual harassment now violated Title VII. In Title VII, doesn't say that sexual harassment is a violation.
No.
They've added that because of the spirit of Title VII.
Yes, because women are a protected group under the Civil Rights Act, and it's obvious that part of the spirit of that law would be to protect that protected group from sexual harassment, a form of discrimination in the workplace.
And again, 1986, conservative court, they are totally accepting the premise that you have to read past the lines and see the spirit of the law.
Yeah.
Which is something that conservatives nowadays do not say that they talk about.
They can do it if it's in their interests.
Right. They'll do it if they're in their interest. But if not, a conservative will never say that they're reading in between any lines. Exactly. They'll never say that.
Yeah.
So now in 1989, we have the shift. We have a shift from a conservative court to a very conservative court. And then eventually with Roberts, we'll have a hyper-conservative court. But right now we're in the conservative court era. 1989, the Rehnquist court comes in and he changes direction. Where do we go from there?
Ward's Cove Packing Co. versus Atonio. So this regards a salmon cannery business in Alaska. Okay. The problem here was that it filled its worst positions almost entirely with Filipinos and Native Americans in Alaska, while the better jobs were almost exclusively held by whites. So these people in the worst positions they sued and they said, there are these business practices that are violating Title VII. There are different hiring tracks for the two types of jobs, and there is a policy of not promoting from within. It seems pretty fishy, right? It seems like you're really trying to keep them out.
Is that a pun? Because we're talking about a salmon
Not intended.
case?
Not
Okay.
intended. It seems like the plaintiffs had a really good case, but the court rules 5-4 against them. And it specifically reversed the ruling from Griggs, which said the burden of proof lies on the corporation to say that these hiring practices are necessary to the business and that they're non-discriminatory. It said that now the burden of proof has to be on the employees and that they have to show that the practices have a disparate impact on the protected group and that those practices were not necessary for the job. And so, that's a huge deal.
Yeah, this is changing the balance of power because before it was like actually giving power to the workers because you're putting more fear in the business side of getting sued. Now the worker sees this massive uphill battle to get what they should get the treatment that they deserve.
Yeah.
Because now they not only have to go to the court and prove that they're getting discriminated against, they have to go to the court and prove the explicit way in which they're getting discriminated against. You know what I mean?
Yeah.
And Blackman, who wrote the dissent in the case, he says that this calls into question whether the majority still believes that race discrimination, or more accurately, race discrimination against non-whites, is a problem in our society or even remembers that it ever was. And this is scathing. I mean, this is going down to the point of like, this is again talking like we talked about last week, when did Reconstruction end? When did, America turn the corner on racism and how we turned the corner? And some members of our society think we turned the corner and walked away from it a long time ago. Others think that we never needed to turn a corner in the first place. And people like that have gone to positions of power, and now they don't want to take any more steps to alleviate racial traumas of the past.
Yeah. Which is simply the wrong view, as racism continues to exist, and it's a problem that the government does need to address.
Yeah.
It's interesting. It reminds me of I think this is from the initial Civil Rights Act, or it might be from a case before the act came out. In one of the earlier chapters we were reading, it talks about how protected groups are given special consideration in cases. And there's an enormous burden of proof that lies on any defendant who's being prosecuted for having some sort of discriminatory practice in place.
Right.
And it's kind of stark to me, especially because this also deals with protected groups, that it gets rid of that, or it's directly contradictory to that like special scrutiny that had been placed on businesses, organizations for discriminating. This is just allowing it to happen.
Something about these hiring tests are above the necessity of that burden of proof.
Yeah.
Right?
I don't get that.
I don't get it at all. And in the same month, so now the Griggs test is gone here. And in the same month, the court would limit the impact of Section 1981 of the Civil Rights Act of 1866. Only apply to discrimination in hiring, not discrimination on the job.
Which again makes no sense.
No sense to me. No sense to me.
Yeah.
I don't. So then we have another case, back to back. We have Birmingham, Alabama, would make it easier for whites to bring cases against affirmative action, trying to get rid of affirmative action back in the 1980s right now, or early 1990s. And like the court was running rampant here. We're going against the Civil Rights Act of 1866. Mm-hmm. We're going against affirmative action. We're limiting the Griggs Act, or the Griggs, what is it? The Griggs test?
Yeah.
So Congress steps up, and they're trying to undo the damage that the courts did. And on November 21st, 1991, President George H.W. Bush signed the Civil Rights Act of 1991, restoring the Griggs test.
Yeah, and this passed enormously in the Senate.
93-5.
Yeah, in the Senate. Crazy.
So this shows that it was really almost bipartisan to be against these court decisions.
Yeah. And
they were angry at the court going so highly and vehemently against the spirit of the laws that they passed.
Mm-hmm.
And they rebuked it. And after this just decimation of the Rehnquist court, the court took a break from discrimination employment cases, but will return when Alito comes. And that's where the shift really comes with Alito. And but I think this was Rehnquist getting a little bit too big for his britches here. I mean, this was him just taking everything he could, just so fast that it was even too much for the conservatives to palate.
I guess so. Yeah, I mean, Rehnquist does strike me as that kind of character. Mm-hmm. The book doesn't talk about it much, but I can see that.
Yeah. So now we'll move on to age discrimination. Yeah. And this one's a little hard for me.
Really?
I think so. I'm curious about your takes on a couple of these cases. But So in 2009, what were we going to say something? No?
Go ahead.
2009, Jack Gross case is going to the Supreme Court. Mm-hmm. So Jack Gross, he grew up in one of Iowa's poorest counties. He developed chronic ulcerated colitis. I'm not a doctor. And was in constant pain since the age of 5. So he's had a pretty hard life. After a lot of work at a company, working there for a long, long time, he was demoted on the same day and replaced by a younger person alongside a bunch of his other older coworkers. It was really like a whole change of the guard. All the old people got demoted, all the young people got promoted.
And he learned that soon after that it was the result of a merger that the company had just gone through.
That's right.
So the new management came in and they wanted to change things up.
Yeah. And he sued under the Age Discrimination Act and Employment Act of 1967, and a jury awarded him $45,000. Eighth Circuit Court ended up overturning this ruling, and then he took it to the Supreme Court. Supreme Court ruled against Gross 5-4, and Clarence Thomas said that you had to prove that age was not just one factor, but the only factor for being negatively affected. The only factor? How could you ever identify the single factor?
Yeah, that's why I think this is like my take on this case is it's ridiculous.
Yeah,
I think it once again seems like kind of a crusade on the part of the court, and they talk about Clarence Thomas in some depth after that in this chapter, and it definitely supports that. I thought that part was extremely interesting.
Mm-hmm. Yeah. I think it's really interesting too.
Yeah.
And Gross said in response, he felt like he felt like his case was hijacked and the court rewrote the law.
Yeah. Well, and I think also it's because the language in the age discrimination law was exactly the same as the language in the Civil Rights Act.
Right.
That prevented discrimination by age or discrimination by a protected group. And never was there a decision on the basis of the Civil Rights Act that said anything like your race or your gender has to be the only thing that led to the discrimination.
How are you even going about proving that?
Like, you have to go through every other possibility and say it couldn't have been. That's ridiculous.
Yeah. My issue with this case, though, comes when we talk about age limits for elected officials. Because I think I am of the opinion that if you're over the age of 75, you should either not be allowed to go for office because you're too old, or you should have to take a test to prove that you're still capable.
I'm not opposed to that.
But does that go against this? Because aren't we discriminating based off age now? So that's why I find difficulty in this whole thing of discriminatory on age, because I'm definitely in favor of some type of regulation of public officials having...
Well, I think the difference is that there was no decline in Jack Gross's performance. And I think they specifically mentioned that in the book.
Okay, yeah.
His performance was still up to snuff.
Mm-hmm.
So I think having something like a test, and I mean, to me, in politics, I feel like I would be up for a test of everyone.
Yeah.
Like, why limit it if the I don't know, if the 33-year-old can't pass a basic test that they're trying to give people to kind of gatekeep them from coming into the government, why should they be able to?
Mm-hmm.
I'm okay with that.
Yeah. I think everyone should have to pass the citizenship test before you run for office.
I don't think I don't know.
I don't know if
I
I
could
could.
pass.
I think we could, dude.
Really?
Actually, I think we could.
I mean, I haven't read it. All I know is I think it probably goes... I mean, I think you could, because it's all about history.
Yeah.
I think it probably goes too deep into history for me to know.
Okay.
I don't know. I think maybe 10% of American citizens could pass it.
I would be so curious to find out what percent of American citizens could pass that test.
I think it would be so low.
That's so depressing.
Well, we're about to talk about immigration in our deep dive, so
right.
We'll get into that.
We'll get into that. So now we're going into the Roberts era here. We're almost there. 2011, court limited the ability of workers to bring large class action lawsuits. This is another one that I don't understand, actually.
Okay, so this is one where I was reading it. I'm like, I don't have time to go into it. I don't know what the rules on class action are exactly, and I feel like the book was a little vague about that. So maybe there's more reason for it. But you should go ahead and describe what happened.
Yeah, right. Like maybe class action means something different than what I think it means, because the book's framing is so obviously trying to put a layup here.
Yeah.
So we could spike it down and say, look how bad conservatives are.
I think so. Maybe.
Right. So plaintiffs are suing Walmart for sex discrimination on behalf of 1.5 million current or former female employees. The court rules 5-4 and held that the case could not proceed as class action because all women had to show that they faced the same injury, and only employees with the same supervisor would be able to do that.
See, I will say that's where I become skeptical even of my initial skepticism. Because why is having the same supervisor more telling than being employed by the same company?
I don't know. I can understand them saying they need to face the same injury for a class action. I can understand that part.
Sure.
I don't understand the same supervisor language at all.
Exactly.
I don't understand that at all, because are they saying that the supervisor is the one you're interacting with the most? And so those are the people who are directly impacting your day-to-day work activities?
I would assume so.
Like, I just don't understand that, though, because Walmart is still the corporation that hired the supervisor.
Sure.
All of the supervisors.
Yes.
So I don't understand.
Yeah, it does seem like Walmart should, as a single entity, be responsible for the mistreatment of the workers.
Yeah. And so they take down these abilities for workers to file these class action lawsuits.
Yeah. And I'll just say here, and Cohen's been making the point over the course of all of these that more than just the decisions that are made, a huge part of the impact is just how much harder it makes it to bring any of these lawsuits for employees going forward.
Yeah.
Right? Because you're risking losing a job, you're risking a lot of legal fees, and with these decisions, it becomes so much less likely that you're going to win and actually be awarded damages that companies are basically given the green light to have more discriminatory practices.
Right. Because, again, it's putting the burden on the plaintiff. It's putting the burden on the worker. Mm-hmm. And the worker doesn't have the capital to go through all the legal fees that the corporation will. So they're less inclined to do it, right?
Exactly.
So now, 2013, the court made it harder to sue for on-the-job harassment. Again, we're saying it's making it harder. Yeah. We have Matea Vance. She was a black woman who had been sexually assaulted while working at Ball State University in Indiana. Her white boss was mean and would hit her and torment her with racial harassment. Colleagues boasted that they had family members in the KKK with her, and the court ruled against Vance. Alito wrote the opinion, 5-4, obviously, and Alito wrote that the specialist who was abusive did not qualify as her supervisor.
Yeah.
Only those with hiring or firing powers were managers, not those giving out tasks.
So this one is interesting to me.
Okay.
Because first of all, say Alito's right. Say or let's not care about the particular point Alito is on. Should companies have some responsibility for treatment of coworkers to each other? Right? To me, it does make a little bit of sense that the act initially limited the responsibility of corporations to be the treatment of a superior to an employee.
Yeah.
But it's hard to ensure, it's really hard, I think, to put that on a company, to make sure that none of its coworkers are bullying the others.
Mm-hmm. Yeah, I mean, bullying is bullying different from racial harassment?
I don't know.
Yeah. I think I would say it is, because I would say that it is. And the company, I think, should be responsible of punishing the worker who is being racially discriminatory.
Okay.
And then if they're not punishing that worker, then they'll have to be problems. So I think you would have to take the case to the company and say, this coworker of mine is racially harassing me, and I want you to take some type of action against it. And then if they say no, then there's a problem. I think they should be enforced by the law to take some type of action.
Okay.
Some type of action.
Bullying is definitely where it gets hard. It's where it gets murky as far as it is, like it's speech. I mean, for me, the testimony that she hit Matea Vance.
Right. And that seems obvious.
Yeah. Like in that case, maybe could she have, or did she? Okay. So talking about the court's anti-union stances throughout the years.
Yeah.
So the book talks about the history of unions. At the very beginning, how anti-union corporations and the government were, even to the point that he brings up the Ludlow Massacre, which saw 20 oil workers, I think, and their families killed because they were on strike. And violence against union workers was common. Yeah.
I mean, we talk about in the 1920s, we have the Battle of Blair Mountain in West Virginia. It's a coal strike, coal miners. And it was the first time that the United States used its Air Force to drop bombs on ground targets. And it was American citizens.
That's wild.
That was the first time, the Battle of Blair Mountain. So being anti-union is built into the American government and corporation systems. But there was some real movement towards collective bargaining power in the 30s with the New Deal. and specifically the passage of the National Labor Relations Act. It recognized the right to collectively bargain, and management and labor was now supposed to negotiate in good faith with one another, and it's being mandated by law, which is a real positive step for union power.
Absolutely.
It doesn't last very long. 1947, after World War II, we saw the passage of the Taft-Hartley Act, and this banned certain types of strikes and pickets, but it didn't totally decimate workers immediately and the unions immediately. So in 1949, 35% of private sector workers were in a union. Today, that number is 6%.
Yeah. And one of the big ways that that's been enabled is through right-to-work laws, which was also a result of the Taft-Hartley Act. And this basically means that workers are allowed to opt in to paying their union dues. And the thinking here goes that a lot of workers are not going to voluntarily opt into paying dues, which is going to weaken unions. And so they're going to basically sit back and enjoy the protection that the union gives them without contributing their fair share. The problem, of course, being that the unions are going to have less power to protect them, the less money that they get from the dues.
It's like the ultimate free rider problem, right? They're getting all the benefits but don't want to pay for it.
Mm-hmm.
And now unions aren't able to demand to pay for it. But during the 30s, we still had some positive movements in workers' favor. One example of this, in 1938, the court wrote the McKay Doctrine. This court order said that companies. This is an anti-union thing in the 30s. In the McKay Doctrine, the court ordered that companies could fill the position of striking workers with permanent replacements.
Yeah.
And this court also struck down many other New Deal programs on top of that. And the court and FDR have very famous hatred towards one another.
Really?
Oh, yeah. I mean, FDR threatened to pack the court if they don't decide on the things that he said. He's like, if you don't decide this way, I'm going to pack the court with people who are loyal to me.
Wow.
He said that verbatim.
That's
why he was the best president.
Sounds like FDR.
That's why he was the best president.
Yeah.
He was like, if you don't do what I want, I will find people who will do what I want, and you will become irrelevant.
It is funny that you're saying he was the best president because of the dictatorial like power that he threatened to use. Like, I will enact my will regardless.
Yeah.
Yeah.
It depends whose will he's trying to enact.
Exactly.
If it's the workers' will, then yeah, I'm okay with that.
Yeah. So McKay Doctrine, this really was a massive blow to the NLRA because it had specifically set out, again, this is spirit of the law, it had specifically set out to protect union workers, including if they went on strike.
Right.
And so the way they got around this is, okay, it's not that you can fire the union workers on strike, it's just that you can fill their positions, which obviously means that once they're off strike, they're going to be fired anyways.
Right. It's like you have the right to collectively bargain, but the right to collectively bargain is really only as strong as your right to strike. In the United States, we don't have a written right to strike. Other nations do. France has a right to strike. If I was ever in federal office, one of my first things would be fighting for a right to strike. But
wow,
right now, we don't. Why are you saying wow?
Just that was like the first message of your presidential campaign.
Yeah. Workers have the right to strike. That's issue number one. Yeah. Second, take down the McKay Doctrine.
Yeah.
Yeah. The Warren Court reverses this trend and kind of is the court FDR should have had.
Mm-hmm.
Oh my God. Could you imagine a different alternative universe where FDR had the Warren Court by his side?
That would be insane.
Insane. Could have had socialism in America. It's a joke, people. It's a joke. In a case from Massachusetts, the court held that an employer could not threaten its workers with losing their job if they wanted to join a union. That's huge. That's huge. We see that today, that corporations are still firing workers for trying to join unions. Starbucks, yeah. Amazon. Mm-hmm. Starbucks had like a lot of shops unionized, and I think they shut down the shops that unionized. So,
yeah.
They still find a ways around it, but this is good that the court is going in this direction. But after Nixon, the attacks continue. What's the first one you have?
I have Reagan firing 11,000 striking air traffic controllers who are in a union, which is credited with drastically reducing the number of strikes that happen from then on out.
Yeah, it was like, how many people did he fire with that?
11,000.
11,000. Yeah.
That's wild.
It's wild to me that he was able to win the union vote after that.
Yeah.
Right?
Yeah.
Like, that's crazy. How was he able to have union bona fides after doing something like that?
That, once again, it screams voter ignorance to me.
Yeah, I don't understand.
Yeah.
I don't understand. So when Nixon comes to power, we have more things going on in okay, let's go here. Attacks continue after Nixon. We're going to skip over to 1992.
Okay.
All right. Union organizers wanted to access the workplaces to speak to employees. Now, this is huge. I've talked to a lot of people who organize unions for a living, who spend their time trying to educate workers on the way to organize and the right steps to take. And this store, Leshmere, threatened to get all organizers arrested for trespassing if their union literature made it into their mall. But not just into their mall, in the parking lot of the mall.
Yeah, the union organizers wanted to put flyers on the cars of employees to inform them about what was happening.
And that was, that's the only way you're going to be able to reach all the employees, right? So Clarence Thomas, obviously they decided against the union workers, and they said that you need their permission and that it was trespassing. And Clarence Thomas wrote that Leshmere could keep the union out of the parking lot. Thomas, and then this is when we get into the background of Clarence Thomas, and you can go into it since you were so excited.
I hope that I can say this well enough. Basically, Thomas grew up dirt poor himself. He grew up with an abusive grandfather because his father was out of the picture. Ended up going to Yale Law School, and somehow his growing up with the poor actually made him more venomous towards them as a justice. The book points out how he is the most cruel justice to the weak, and it also talks about how. So during his confirmation, a piece of news came out where I think Anita White was her name.
Anita Hill.
Anita Hill accused him of sexual assault in high school, which of course Thomas denies. And it made it so that his Senate confirmation vote was the closest that there had maybe ever been, or had been in like 100 years or something. It was 52 to 48. The book cites confidants of Clarence Thomas that had been reported on afterwards, and how they said that the closeness of that vote kind of embittered him and made it so that he wanted to get back at the liberals. And there's some quote specifically saying like, I'm going to live long enough, I'm going to vote in enough of these decisions that I'm going to make them regret that this is what happened. And this was kind of his first step in doing so. And since then, he has arguably been the most conservative justice on the court. Still there today.
Still there today. Joe Biden actually ran the Anita Hill hearings.
Really?
He was the chair of the Judiciary Committee when Clarence Thomas was getting appointed.
Wow.
And he ran the Anita Hill meeting. From the progressive perspective, he wasn't hard enough on Thomas. From the conservative perspective, he was too hard on Thomas, obviously.
Shocker.
Right.
Sounds like the story of Joe Biden's life.
Yeah, exactly. One other small tidbit about Clarence Thomas to really show the type of man he is. His sister was very poor. Is very poor, and he said about his sister that she gets mad when the mailman is late with her welfare check. And this is the type of guy who's basically writing the laws that affect all of us. Yeah. A guy who is that unsympathetic to even his own sister.
Yeah, and who's receiving gifts from billionaires to fund his own life.
Yeah, please. Oh, God. Fucking bite me.
Yeah.
So now we'll get into the attacks on public sector unions from the court.
Yeah.
Public sector unions are pretty important in American politics. They are overwhelmingly in favor of Democratic candidates. They are some of the most consistent donor bases of Democratic candidates, even the workers in public sector unions. So it's an important. It's a partisan attack against these unions as much as it is an attack on unions themselves ideologically.
Yes.
This is also about weakening the Democratic Party in a way. So 1977, the Burger Court, Abbott v. Detroit Board of Education. We have some school teachers arguing that their unions were using their dues to promote political causes or religious causes that they did not agree with and wanted to not be forced to give these unions the money. The Abbott Court ruled that the money given to the unions could only be used for collective bargaining purposes and nothing more. I agree with that.
Yeah, it was kind of a compromise because the justices agreed, they conceded that unions shouldn't be able to spend money towards causes that the employees who are paying their dues might not agree with. So they're saying, okay, but they also see how much unions would lose power if workers weren't required to pay their dues. So they're like, let's strike a compromise.
Right, and I think that's the perfect compromise. I don't think that unions, public sector unions, should really be in the politics of spending their money outside of collective bargaining anyway.
I agree.
I think they should be focused on organizing collective bargaining stuff. So I don't really disagree with that opinion. So now 2011, states with Republican governors scale back the rights of unions. So think about what's going on in 2011. Obama was elected in 2008. 2010 was the massive Republican wave. Just like 60 plus seats in 2010.
Was it? I thought
Massive.
What the book said is that the Democrats overperformed.
In 2010?
So that's what I thought it said.
No.
Because that's why it said the idea was that Republican governors were almost taking revenge with increasing right to work laws.
Oh, no. 2010 was the worst decimation of the Democratic Party.
Really?
Oh, yeah.
Okay.
Yeah, the absolute worst. I mean, we're talking 60 plus seats in the House gone.
Wow.
Yeah, we're talking more governor mansions flipped, I think, in any other year ever. Like it was one of the worst elections for an in-party party in power. Actually, now that you got me curious, I'm going to look up the 2010 election results generic ballot. I want to see how much it was here. So it was a 10-point lead. The Republican won the overall vote by 10 points in 2010 across the country.
Wow.
Yeah. So that was the rise of, honestly, like the modern Tea Party movement was 2010. So states that were Democrat for a long time, specifically Wisconsin, started, even states like Wisconsin elected Republican governors. And so this is when right to work laws really started exploding. And Scott Walker from Wisconsin gets to power, and he limits the ability of unions representing government workers to engage in collective bargaining, period. Scott Walker is one of these guys who's really ideological, and he was the darling of the Republican Party in this 2010 to 2018 era. Like, he was the man. To be honest with you, Scott Walker is, take Scott Walker out and put in Ron DeSantis, and they're playing the same role.
Okay.
And honestly, it's playing out even more like a rhyming poem, because Scott Walker, when he ran for president, was supposed to be the front runner and then got decimated. And it looked, and Ron DeSantis was propped up, supposed to be the front runner, and apparently he's getting decimated. So the Scott Walker Ron DeSantis parallels are insane.
Interesting.
But Scott Walker gets to power in Wisconsin, limits the rights of public sector unions for collective bargaining. 2012, Indiana is adopting right to work legislation. And then we have cases coming up that are challenging how agency fees are calculated. Agency fees are those union dues that public sector workers pay, right? Alito suggests that the concept of a mandatory agent fee could be up for grabs. He doesn't go in so far to say as we need to eliminate the agency fee entirely, but Alito is opening up the door. And when this case was supposed to go to the court and be heard, Scalia died, meaning that the court was now a 4-4 court. Obama was president at the time, but he didn't have control of the Senate. So he nominates Merrick Garland, and the Republican machine went into overdrive to stop this nomination and never held a vote. Republicans held the seat open until Trump appointed Neil Gorsuch, and the conservative court was held together through lies, deception, and
the filibuster.
The
threat of the filibuster, at least.
Yeah.
Yeah. And so once Gorsuch is confirmed, Janus v. American Federation of State, County, and Municipal Employees comes along and the court has the conservative majority it needs to eliminate required public union fees.
Entirely gone.
Yeah.
Workers could now opt out of these fees and leave the unions poorer, smaller, and less able to advocate for their members.
Yeah.
After Michigan passed similar legislation to this, they saw a decrease of 28% of their agency fees being paid to them.
Yeah. There was decreases in government employment across the board.
Mm-hmm. Yeah. And so this is just areas where the public sector unions are just getting decimated, and the balance of power has completely shifted by this point to the hands of the corporations entirely.
Yeah. And that's kind of the next part of this chapter is it honestly, I don't want to spend too long on it because we already talked about how the court has given corporations more power, and it references Buckley v. Vallejo, which is a case we talked about in a prior episode, which has allowed unlimited spending from corporations. And so corporations now consistently outspend unions significantly in elections. In 1978, unions outspent corporations. Now corporations spend about 7 times as much as unions in elections. But there haven't been, the book didn't talk about any cases that happened with this. It was just like, because of something the court did in the past.
This is what's happening now.
Yeah.
And right to work laws are springing up all over the place. This is the main goal. But when right to work gets on the ballot, it doesn't win very often. Missouri was a good example of this. Missouri, not a liberal state, put a right to work piece of legislation on as a referendum on the ballot, and Missouri voters overturned the law from a 2-to-1 margin.
Yeah.
And in most cases, union membership will drop 5 to 10% after a right to work law is passed in a state. So it really will decimate it. He goes on to talk about the minimum wage. We all are, I feel like we've talked about the minimum wage a lot, but
totally.
Yeah. So France's minimum wage is 60.5% the median wage. The US is only 35. He suggests that the reason that the minimum wage is what it is because of
corporate power that the court has given over the years.
And the way that corporations are able to give money to candidates.
Exactly.
How do you feel about that? I mean, I know you don't really... Do you think it's tied? I think the minimum wages is weakest, but you think it's totally tied?
I actually do. I mean, again, if I'm thinking that policy tends to follow the money, there have been several polls that say that a majority of Americans are in favor of raising the minimum wage. And I feel like in a lot of these red states, it might even be it might be more helpful. So to me, this is corporate greed getting in the way.
In 2020, Trump wins Florida, but a referendum to raise the minimum wage to $15 won across the state.
Yeah.
So, and I guess that kind of is the end of this chapter for me.
Yeah, same here. I just found this 62% of U.S. adults don't just say they favor raising the federal minimum wage. They say that they favor raising it to $15 an hour.
Yeah.
That's a lot.
And there isn't even a movement in Congress to even touch that, really.
No, I mean, I hear Bernie talking about it.
Of course, you hear Bernie talking about it. You'll hear Warren talking about it, Ed Markey talking about it, but not enough, ever.
No.
So that's the next chapter of Supreme Inequality down. I don't know what the next week's one. Be on your toes.
Yeah, should be exciting.
Yeah, should be exciting as always. Just a little depressing.
Just a little.